So let us start with the chapter prospectus. This is a very important chapter for examination, and many questions in this chapter students will not even study. I don't know what complexity they are failing in this chapter, but most of them are not preparing well for this chapter. So let us start with the chapter prospectus and do some revision. So around 22 questions are there which are non-repetitive in nature. Those questions I will cover. Remaining are either conceptually repeated or same question repeated in exam. Those I will not unnecessarily waste your time. Okay, I will complete and cover. See, first one. What are the provisions relating to the private placement of shares? November 2018, this question came for 8 marks in exam. Therefore, there is a point of writing everything in the exam. So, this one question, if you read, any question that comes in private placement, whether 3 marks, 2 marks, multiple choice question for 1 mark or 4 marks or 5, 6, 7, 8, anything you can write. So, let us cover this. So, first I will explain what is a private placement. Company issuing the shares to a selected group of people. Identified selected group means what? Company only will identify. Okay, give to him, give to him, give to him, give to him, like that. It will identify that identified group of people. If you give the shares, we call it as a private placement. We call it as what placement here? Private placement. Okay. So private placement means an offer. It's an offer given. Whether that person will accept or not, we don't know. Offer of securities or invitation to subscribe the securities to a select group of persons. That's why identified group, selected group persons by a company other than by way of a public offer through the issue of private placement offer letter. What placement? Private placement offer letter, and which satisfies some conditions. So first one, company, what it will give? It will give offer. Offer of what? Offer of securities or invitation of security, subscription to securities to a select group of people. Listen carefully. What is the significance of that select group? If a company is going for a rights offer, rights issue, a company must give offer letter to all the existing shareholders. Okay, but here you can select to whom you wanted to give. Their selection not possible. Here selection of members is possible. Next, conditions. First one, point number 1. Company may, subject to the provisions of this section, make the private placement of securities. So, section compliance is mandatory. That's the meaning. Next, first, a private placement shall be made only to a select group of persons who have been identified. Selected group identified by the board. From now, they will be called as identified persons whose number shall not exceed 50 or such higher amount as may be prescribed. As of now, 50. Maximum to how many you can make? 50 people you can make a private placement. Okay. Okay. Next, in that 50, who will not be included? QIBs are not included. Employees are not included. Okay. Okay. So excluding QIB and employees of the company being offered securities on the scheme of employee stock option, not opinion by mistake, employee stock option in terms of section 62(1)(b) in a financial year. So therefore, tell me, private placement will be made to a select group of persons identified by the board of directors, number not exceeding 50, which shall not include qualified institutional buyers and employees who were issued shares under employee stock options. Okay. Next, number 3. A company can make a private placement only by issue of private placement offer and application in such a form as may be prescribed. So rules we will read. Next, every identified person willing to subscribe to the private placement issue shall apply in the private placement, and application issued to such person along with the subscription money paid either by check or by a DD or by any other banking channel, but not by a cash. Simply to tell, any identified person, we selected some group na, if he is willing to subscribe, why they use the word willing? Why they use the word willing means it's an offer. If you want, you can accept. If you don't want, you need not. So if you are willing to subscribe, okay, first you have to fill the application form. Not just application form, application money also should be paid. That's called as a subscription money. Should be paid either by of a check, DD, or any other banking channel, but not in cash. Okay, but not in cash. Next, a company shall not utilize the money raised, shall not utilize the money raised through private placement unless allotment is made. You paid subscription money. Now allotment will be made. Unless allotment is completed, you cannot utilize the application money that is received. Okay. Not only just allotment is made, but also return of allotment should be filed with the registrar. Next. Next. No fresh offer or invitation under this section shall be made unless the allotment with respect to any offer or invitation made earlier have been completed, or that offer or invitation has been withdrawn or abandoned by the company, provided that, subject to the maximum number of identified persons under subsection 2, a company may at any time make more than one issue of securities to such class of identified persons as may be prescribed. Okay, I will give a minute time. Read this point properly. Read it. Completed reading. Okay, let's see. So, no fresh offer or invitation under this section shall be made unless the allotment with respect to any offer or invitation made earlier have been completed. So, fresh offer of this private placement shall not be made unless the previous offers must be either completed, means complete money has been received, or either it should be withdrawn, decision taken but withdrawn, or it is cancelled. Anything you should have done, means when the active offer is going on, another offer you cannot make. Okay. However, maximum number of identified persons is 50. Okay, under subsection 2, a company may at any time make more than one issue of securities, okay, to such class of identified persons, means 2 3 private placements we cannot make. For example, 50 people we made, now another 50 we made, another 50, like that we cannot make. Okay, first 50 offer should be made, that offer should be completed, then you go for another private placement offer. Okay, however, first I make to 10, next I will make to 10. Within that 50 you can make any number of private placement, but 50 multiples you cannot make unless the offer is fully subscribed. Next, a company making an offer or invitation under this section shall not allot its securities, shall allot its securities. Same, normal company concept. Within 60 days from the date of receipt of application money for such securities. And if it is not able to allot this, it shall repay the application money within 15 days after expiry of that 60 days. And if company fails to do so, 12% interest has to be paid from the expiry of that 60th day. Means from the 61st day onwards, till when you will refund for that 15 days or 20 days, whatever the case may be, 12% per annum interest you have to pay. So allotment must be completed within 60 days of receipt of application money. If you could not get the allotment application money within that time, if you could not allot it within 60 days from the application money receipt, you have to refund it within a period of 15 days from the expiry of that 60 days. Okay, if you do not, you have to pay interest at the rate of 12% per annum. Next. And moreover, money received on application should not be kept in company's bank account. It should be kept in a separate bank account with a scheduled bank. Next. And should not be utilized for any purpose other than adjustment against the allotment or repayment of money back if it could not allot the securities. No company issuing securities under this section shall release any public advertisements, any media, TV, hoardings, etc. It should not, because it's a private placement. Public are not allowed, no advertisement. A company making any allotment of securities under this section shall file with the registrar a return of allotment within 15 days from the date of allotment. That's the main point. Within 15 days, you should file a return of allotment. Default, this is a punishment. Okay, default, this is a punishment. Next, if a company makes an offer or accepts money in contravention of this section, then promoters and directors shall be liable to a penalty which may extend to the amount raised. What is the penalty? Whatever amount you raised with fraud, that much amount or 2 crore rupees, whichever is lower, and company shall refund all the money. That's it. This point is not required. 10 points we completed. This is all regarding the private placement program. Just next question. This is not a exam question. This is only a general question. I am not going to cover. Since this is tested in examination, some examination RTP, MTP I will put. These are all general questions I kept. So this you can read later. Next. Yeah. Abridged prospectus, May 2009 question. What is meant by abridged prospectus? Is it necessary to furnish abridged form of prospectus along with the application form for the shares? Under what circumstances abridged prospectus need not accompany the detailed information relating to prospectus along with the application form? Read the question first, we will continue. Okay, read the question. Okay, see here. So first thing you need to understand why companies go for abridged prospectus. Companies will go for abridged prospectus because prospectus is a bulky document. It contains 500, 600 pages document. It will be very difficult to circulate physical documentation in that kind. Therefore, section 2 clause 1, the first definition of Companies Act is talking about abridged prospectus. Okay. So what is the meaning of abridged prospectus? Abridged prospectus is a prospectus which does not contain complete details of the company, but it will contain the salient features, means important features. An abridged prospectus means a memorandum, means a statement containing salient features of a prospectus. Okay, such salient which are said in the rules. What are those? Let us go to the down and first complete that. What should be there as per SEBI disclosures? A copy of abridged prospectus shall be submitted to the board. Shall be submitted to the board. Board here represent Securities and Exchange Board. Information which is of generic nature and not specific to the issuer shall be provided in the form of general information document as specified by the board, and which shall be available separately and not to be included into the draft offer document and the offer document. The abridged prospectus shall be printed in a booklet form. So abridged prospectus should be in a booklet form in A4 size paper, and along with the application form and the revision form, and shall not be exceeding, okay, 5 sheets. 5 sheets printed both sides. Additional sheets may be appended for bidding centers. Abridged prospectus shall be printed in a font size which shall not be visually smaller than Times New Roman size 11 or equivalent with 1.0 line spacing. Like that, they clearly said that much. If you say, then only clarity will be there. Salient features of prospectus. Actually, this is not applicable for CA intern. I just kept this for your understanding. That's why just read and leave. Okay. Abridged prospectus must be submitted to the board of Securities and Exchange Board. It should contain, if any information will be of two types. Number one, specific information, general information will be there. General information will be there. If it is a general information and not a specific information, it's a general information about the company and the industry. Separately, you should write it in the general information document. Okay, it should not be forming part of abridged prospectus. Next, abridged prospectus should be in the form of a printed booklet, A4 size paper, and should not exceed 5 sheets, printed on both the sides, and it should follow a Times New Roman font, size 11, with only one spacing. Just read and leave. So now, what is an abridged prospectus under section 2.1? Abridged prospectus means a memorandum containing the salient features of the prospectus. Next, abridged prospectus to be issued along with the application form. Sir, what is this? I will explain first. You know, na, application money, allotment money, first call, second call, final call, like that. So many things are there. Na? Always remember, whenever you are issuing the application form for accepting application money, application form must be attached with the abridged prospectus. Means first know about the company's salient features. After understanding everything about the company, then fill this application form and pay the application money. Therefore, every application form should be attached by the abridged prospectus. No application form for purchase of any securities of a company can be issued unless such form is accompanied. Which form? Application form. Accompanied means attached by abridged prospectus. Abridged prospectus and application form should bear the same printed number. Investor may detach. That means abridged prospectus and share certificate, share application form will be there. Perforated pages means holes will be there. Just you need to remove that. The investor may detach share application form along with the perforated line after he has an opportunity to study the contents of the abridged prospectus. Then you write in the application form and give. Today anyway we are not following all this because online we are doing all this. Next, objective of abridged prospectus is to reduce the cost of issue, as the detailed prospectus is a very bulky document, whereas contents of abridged prospectus are limited. Okay. Next, however, a copy of full prospectus shall, on request by any person before closing date of subscription list and offer, may be furnished. If he asks, we will give. Penalty 50,000 up to 50,000 rupees if there is any default. Means if application form is given without a abridged prospectus, 50,000 penalty. Next, very important is this one. When abridged prospectus is not required, okay, if the issue of shares is made to the underwriters under the agreement. Why underwriters will agree to underwrite? After learning everything about company. When they know everything about company, why they again require salient features? In that everything salient also they know. So in connection with bona fide invitation to a person, you enter into underwriting agreement in respect of such securities, okay, or the securities which are not offered to public. When the issue is not to the public, only to the private people, they already know about the company. Why you are telling about the company again in the prospectus? Prospectus contain details of company. Existing shareholders already know about it. That's it. Next, question 5. What is the meaning of a shelf prospectus? Okay, what is the meaning of shelf prospectus? This is a very important question here. Shelf prospectus and information memorandum. Information memorandum. So repeated questions are then I will not discuss again and again and waste your time. Let us first focus on the shelf prospectus and try to understand. First, listen carefully. I will explain. What is a shelf prospectus? Whenever the companies are going for having an idea to go for multiple public offers in the same year, okay, multiple public offers in a span of 12 months period, okay, they wanted to go for one public offer, multiple public offers if they wanted to go in a span of 12 months, If they are going for 3-4 public offer, 3-4 times prospectus, 3-4 times issue expense, 3-4 times documentation, 3-4 times legal expenses, like that we need to incur. In order to avoid all this nonsense, lawmaker has given one chance. What is the chance? In case a company is issuing a shelf prospectus, in such case, they need not issue prospectus again and again. They can issue one prospectus which will be valid for a period of 12 months from the date of first offer. Today, first public offer started. From today, 12 months. It's not financial, it's not calendar year. 12 months from the period of first offer of securities. 12 months, any number of public offers you can go. Again and again, prospectus need not be issued. Okay. So, first thing what we need to do, shelf prospectus you need to file with the registrar. Okay. One prospectus you need to file. Remaining, keep it in the shelf. Whenever some important changes happen, means new charges created on assets, board of directors change, financial position of some important changes came, those to be informed or not, those will be informed in the form of a information memorandum. Okay, let's see. Shelf prospectus means a prospectus in respect of which securities or class of securities included therein are issued for subscription in one or more issues over a certain period, 12 months period, without issue of any further prospectus. Section 2 clause 70 defines as follows. According to that, prospectus means, what is the prospectus under section 2 clause 70? Prospectus means any document described or issued as a prospectus. Not only that, it includes red herring, shelf. So shelf prospectus is one of the prospectus. Point 2. Hence shelf prospectus is a prospectus. Next, need and advantage we don't need. Directly come to filling of information memorandum. However, under section 31(2), a company filing a shelf prospectus shall be required to file information memorandum on what? On all material facts relating to new charges created, changes made in the financial position that have occurred between first offer and any previous offer and succeeding offer. Means the first offer or previous offer and succeeding offer, between any important things happen. Anyway, I made 5 public offers. Two completed. Now we are in the month of December 2024. Now what happened? December 1st, first offer started. January, another public offer we are going. Again we have to issue prospectus. No need. But in this 1 month gap, some important changes happened. That important information will not be there in the prospectus because this prospectus was printed before this event happened. But the next coming person should know about this. That's why we will file information memorandum. Okay. So, first offer of securities and previous offer and succeeding offer of securities up to their required. Remaining is only rule content they are saying. As per rule 10, the information memorandum shall be prepared in form PAS2 and filed with the ROC along with the fee within 1 month prior to the issue of second or subsequent offer. Next. Section 31(3) states that where an information memorandum is filed every time an offer of securities is made under 31(2), such memorandum together with the shelf prospectus shall be deemed to be prospectus. Means information memorandum plus shelf prospectus which is already issued for the first time, both together will be treated as a prospectus. What do you mean by that? If in the information memorandum you put any wrong information, for that also misstatement of prospectus, what punishment will apply, that punishment only will apply. Okay. Next. So SEBI may provide the regulations in case of listed company to file shelf prospectus. Shelf prospectus is to be filed at the stage of first offer of securities. Shelf prospectus shall indicate a period not exceeding 1 year as a period of validity of prospectus from today. I said 1 year, not 1 calendar year, 1 financial year, any 1 year. Such period shall commence from which date? Date of opening of first offer of securities. In respect of second offer of such securities, during the validity of the prospectus of 1 year period, company need not issue any further prospectus. Company which has issued shelf prospectus has to file with the registrar an information memorandum. That's it. Please read the section clearly. Shelf prospectus. First, write down the definition of shelf prospectus. Next, write down the provision called as prospectus and tell that shelf prospectus is one of the prospectus. Then you should write about the shelf process. Shelf prospectus is a prospectus which is issued once for the offer, which has a validity of certain period of 1 year, and for without any further issue of securities, company can go for public offer. However, if any material changes happen, like new charges created, financial position changes, etc., it should file information memorandum with the ROC in form PAS 2. Next, after that, then you have to write down these points. These 6 points are must and should written points in exam. Most important, read these 6 points first. Read the point. Okay, done. Next one. Information memorandum already covered. I'm not going to discuss again. Next, deemed prospectus under the Companies Act. Okay, see here. What is a deemed prospectus? Okay, what is a deemed prospectus? Listen, deemed prospectus means it's not really a prospectus. We will assume that it has a prospectus. When does this all happen? Listen carefully. When deemed prospectus happens is, look here, there is a company. There is a company. That company cannot go to public directly because public don't know about them. What they will do is they will put a channel in the middle. Moderator will be there in the middle. Means what? For example, public may not know XYZ Limited, but public know HDFC Capital, Axis Capital, Kotak Securities, SBI Cap Securities. Clear or not? Means rather than company directly going into public, these people who are already having the popularity and credibility and reliability in the market, they will propose to the public, you buy these shares. Like that they will do. See here, there is a company. Okay, regular class hours and hours I will explain this. So in a revision of this question, I need not explain actual. I should assume that you know, but there is every chance that there is a situation where you may not know about this. So listen carefully. There is a company. There is a issue house, public. Okay. Company, issue house, public. Issue house means experts in the middle. Company will issue prospectus to issue house. Issue house will read the full prospectus, understand whether this is a good company or not. When they suggest this to others, whether it will be successful or not, they should first believe. They're experts, investment bankers. Once they feel that everything is going well, this issue house will first give the money to the company. Okay, and company will third stage transfer the shares to issue house. Issue house will take the shares for that money given. So first what happened? Company issues the prospectus to the issue house, and the issue house will transfer the money. For that, shares are also transferred to issue house. Now the issue house will offer these shares to whom? Public. For public to subscribe to that securities or to that particular shares. Public will subscribe to those particular shares, and public will give the money to the issue house. What issue house will do? Issue house, what it will do is, the money at which it will transfer it to the public. That means whatever the money they get here, if it is 100 crore, company will agree. The issue house will agree to give to the company only 92 crore. That 8 crore or 6 crore or 5 crore, whatever the case may be, is a commission. Commission to whom? For doing all these things, the issue house will charge a commission. So tell me, company issuing prospectus to issue house to make issue house a investor? No, with a view that this issue house will allot the securities, or it will offer the securities to the public. Okay, now listen carefully. Who issued prospectus? Company issued prospectus to the issue house. What issue house has done? Offer letter it has given. To whom? To the public. Offering securities of which company? This X Limited company. Therefore, what law said is, company issued prospectus to issue house. Yes, that is already a prospectus. You need not deem. Issue house issued offer letter to public on the basis of the prospectus. Yes, that will be deemed as a prospectus. And if there are any humbug information, any wrong information, false information, untruthful information, anything is there in that offer letter, this issue house will be liable. That's the concept. Okay, let's see. Now keep the diagram in mind, read it. Any document by which an offer for sale of securities is made, issue house to public, and the company allots or agrees to allot securities, company allotted securities, then such a document, which document? Offer document, shall for all purposes be deemed to be a prospectus, and all the rules of law etc will be applicable also for that application form, for that offer letter. Next, issue of prospectus is not necessary in the following cases. Means our prospectus is not required in these two cases. When the shares are when the shares or debentures are given to the existing shareholders, they need not know about company because they already knew. Next, when the issue relates to the shares or debentures which is uniform in all the respects which are previously issued. Already I issued shares, same kind of shares I am issuing again. No need to issue prospectus because those prospectus is enough for you. Next, irregular allotment is asked in November 15. After that they didn't test because now it is not there in your study material. Next, I will do one thing. I will come from the last because those questions are the latest RTP MTP questions. Okay, that's why previous exam like MBL Pharmaceutical Limited is committed to provide quality medicines at an affordable cost through the relentless pursuit of excellence in its operation, product quality documentation and services. Companies are now focusing on oncology, therapeutics, and other generics with a vision to be a global leader in the oncology. The prospectus issued by the company contains some important extracts of expert report on research by oncology department. The report was found untrue. The report was found untrue. Mr. Divakar purchased the shares of MBL Pharmaceutical Limited on the basis of expert report published in the prospectus. Will Mr. Divakar have any remedy against the company? State also the circumstances where an expert is not liable under the Companies Act. Wow, super question. Yeah, 5 marks, May 2023. Read the question first. Enough time taken. I gave time for you to read because similar question can also repeat. Okay. See, MBL Pharmaceutical Limited is committed to provide quality medicine for at affordable price, etc., etc. Everything is there. Okay. So, company issued a prospectus. In that expert statement is there. That expert statement is found to be untrue. Mr. Divakar purchased the shares on the basis of expert report published in the prospectus. Will Mr. Divakar has any remedy against the company? First, listen carefully. Point number one. Whenever expert statement or false statement is there, that's called as a misstatements in prospectus. Which statement here? Misstatements in prospectus. It makes the prospectus invalid. Okay. So see here. Where is it? Yes. Under section 35, where a person has subscribed for the securities of a company, where the person has subscribed for the securities of a company, acting on any statement, means if a person subscribed to the securities on the basis of expert statement, on basis of any statement, in that expert statement is also there, included in the prospectus, which is misleading, and because of that, if he sustained any loss or a damage as a consequence, company and every person, including an expert, shall be liable to pay compensation to the person for the loss or damage. In the present case, Mr. Divakar purchased the shares of MBL Pharmaceutical on the basis of expert report published. Okay. Next, what he can claim? He can claim compensation for any loss or damage. Not only that, the persons who authorized that prospectus shall be punished under section 447. Expert will be punished under 447 for fraud. Along with that, circumstances when an expert is not liable. Okay. When expert will not be liable, expert when he will not be liable is expert has given his expert statement and consent also given that I have given. Auditor will sign na, I have given audit report. Like that expert also should tell that yes, I have given. Letter headline he will give. If really when expert will not be liable, when expert is not liable means that expert should withdraw the consent which is given in writing before delivery of prospectus for filing with the ROC. Next. Okay. Or if he can prove that, prospectus was issued without his knowledge or consent, and upon becoming aware of it, forthwith, immediately, he gave a newspaper advertisement, public notice that it was issued without his knowledge. So, he did not give, but in his name someone has given. Once you come to know about it, immediately you should give a public notice saying that that was not given by you. Next, an expert will not be liable in respect of any statement not made by him in the capacity of an expert and included in the prospectus. General discussion like Twitter lo one message was kept. That was taken as an expert consent and they have included in the prospectus. No, I should give in the prospectus only. Any other side, general discussion, if I say something, not in capacity as an expert, if I say something, I will not become liable. Three situations we read. When expert is not liable, expert is not liable if he withdraw the consent before its filing. Expert will not be liable if the prospectus is issued without his knowledge and upon becoming aware, immediately give a public notice that it was issued without his consent. And the third one, it was not made by him in the capacity as an expert. Next, as regards to every misleading statement purported to be made by an expert contained in any copy or extraction or anything, it was a correct or fair representation of a statement or a correct copy of or a correct and fair extract from the report or valuation, and he has a reasonable ground to believe and did up to the time of the issue of the prospectus believe that person making the statement was competent to make it, and that the said person had given consent required under section 26(5) to the issue of prospectus and had not withdrawn the consent before filing of the copy of prospectus with the registrar to the defendant's knowledge before allotment thereunder. Sir, I did not understand one word also. Listen, read it once, I will tell you the meaning. I will simplify also, first read it. Okay. Now, so as regards every misleading statement purported to be made by an expert. Okay. So first, misleading statement which is complained that it is made by whom? Expert. Where expert has made that misleading statement, it is contained in a copy of, or it is contained in an extract from a report, either separate expert report he has given, or in some report that expert content is there. For example, separately expert statement is given, that copy, or expert statement is not separately given, there is a book, in that book expert statement is also there, extracted from that report, or expert statement is there in a valuation made. So misleading statement, as regards to the every misleading statement purported to be made by an expert, contained in a copy, or contained in a extract of a report, or contained in a valuation made by an expert, it was a correct and fair representation of the statement, or correct copy of, or correct and fair extract from, or correct report or valuation, and he had a reasonable ground to believe, and did up to the time of the issue of the prospectus believe that person making the statement was competent to make it, and that the said person had given consent required under 26(5). Here what he is telling, when a person will not become liable though there is a misstatement in prospectus. For example, I am a director. I am from, say, IIT. Okay, I am from IIT. Now, answer my question clearly. I am not from medicine side. I am from IIT side. Okay. Now, I signed on the prospectus. In that prospectus, expert statement is also there. That expert statement is on oncology, etc. Okay, they gave expert statement there. Expert report was given. I am a IIT graduate. I don't know about medical thing anything. Okay. Now, what I will believe, I signed. Okay. In that in that oncology expert report, there is a mistake. You are saying that director you signed, you are also liable. I am saying that, Array, I am liable. I am liable. But try to understand clearly, I don't have any knowledge. I believe that the person who made it is an expert. Okay. Any content made by an expert, I believe that everything is true. Sir, why experts are there? Experts are there because we need to believe them. If you don't want to believe, then what is the purpose of any expert here? Advocate is there, he will give some expert advice, we will believe or not. Why? Because he's an expert in that field. So he said that I have a reasonable ground to believe. Okay, and I did believe it up to the time of issue of prospectus. I believed that expert statement is true because it is made by an expert, and I believe that he is having a qualification to do so, and that fellow also have given consent to that. So I believe in his statement and I signed on the prospectus. Okay, so try to understand, a innocent person who signed on the prospectus, okay, believing that expert has a competence to give a report, then he will not become liable. So with this, we completed question number 41. Next, question number 40. The board of directors of ABC Limited are proposing to raise funds from the public through the issue of equity shares. However, due to volatile financial markets, the price per share and the number of shares to be issued are left open and to be decided post closure of the issue. As a financial advisor, what would you suggest? In that case, you have to issue red herring prospectus, which issue a red herring prospectus. Red herring prospectus is a prospectus which does not contain the complete information about, okay, complete particulars about, okay, the number of shares to be issued and the amount at which it should be issued. So it does not include complete particulars complete particulars of the quantum or price of the securities included. So how many shares to be issued, at what price should be issued, will not be there anywhere in the prospectus. Such prospectus is called as a red herring prospectus. Next, thus ABC Limited may raise the funds through the red herring prospectus, whereby price per security and number of securities are left open to be decided post closure of issue. Next, red herring prospectus should be issued prior to the prospectus. Means prior to the issue of final prospectus, first issue red herring prospectus. Okay, see how many shares are subscribed using that. On that basis, you decide a price and number of shares to be issued. Company proposing to make an offer of securities may issue red herring prospectus prior to the issue of prospectus. Okay, file with the registrar at least 3 days prior to opening of first issue. Obligations under red herring prospectus, whatever the obligations are applicable for final prospectus, All are applicable also for red herring prospectus. Next. So first you will issue red herring prospectus. In that price, number of shares to be issued will be blank. Okay, on the basis of the demand received, okay, at the closure of issue, we will decide how many shares at what price. That's called as a red herring issue, red herring prospectus. Am I clear? So any variations are there between the main red herring prospectus and main prospectus, you have to mention them as the variations. Okay, filing of red herring prospectus with the registrar. Upon closing of offer, the prospectus stating total capital raise, either by way of debt or share capital, and the closing price, which is not included in the red herring prospectus, shall be filed with the registrar and SEBI. Read ya. Market also as important question for exam. Okay. Next one. Private placement. Already we covered everything. Next. Johnson Limited goes for public issue of shares. The issue was oversubscribed. A default was committed with respect to the allotment of shares by the officers of company. There were no managing director, whole-time director, or any other person designated by the board with the responsibility of complying with the provisions. State who are the persons responsible as officers in default under the Companies Act. 5 marks. Read the question first. Okay. So let's see the question first. What is the focal point of this question? The company went for public offer. Issue was oversubscribed. Default was committed in respect of allotment of shares by the officers of the company. Okay. So what happened? Let us see. As per section 39, which deals with allotment of security, state that in case of any default relating to minimum subscription and the return of allotment of money, the company and officer in default shall be liable to a penalty for each default 1000 rupees for each day, which can exceed up to 1 lakh rupees. Okay, which can exceed up to 1 lakh rupees. So officer in default. Okay, so any default committed at the time of issue of securities, what will happen? Officers in default will be liable. Officer who is in default. So who is an officer in default? Whole-time director, KMP. Where there is no KMP, such director or directors as specified by the board are all directors if no director is so specified. So if any director is mentioned separately, he has to take the responsibility of prospectus, he will be liable, that director, or else all the directors will become liable. If whole-time director is there, he will be liable. If KMP is there, he is liable. Okay, where there is no KMP, so which director is authorized by the board to take the complaints, he will be liable, or else all directors will become liable. Any person who under the immediate authority of the board, okay, that fellow, like that, these persons will be liable. In the given case, as stated, Johnson Limited committed a default with respect to allotment of shares by officers. As in company, there were no MD, whole-time director, or any other officer designated, okay, who will be liable here with the responsibility. Therefore, such all directors of the company may be treated as officers in default. Again, private placement. Okay, next. RD Limited issued a prospectus. All the statements contained therein were literally true. It also stated that company had paid dividends for a number of years, but did not disclose the fact that the dividends were not paid out of trading profits but out of capital profits, which is not correct. An allottee of the shares claims to avoid the contract on the ground that prospectus was false in material particulars. Decide that the argument of shareholder as per provisions of Companies Act is correct or not. Okay, listen carefully. This question was asked on misstatements in the prospectus. Listen carefully. Whenever we talk about a prospectus, misstatements in the prospectus means how much wrong it is to give wrong statement, that much mistake is to omit a material fact. Omit a material fact. That's also called as a concealment of fact. Concealment of fact. It will also be treated as a fraud under Companies Act. Okay. So 34 section deals with 34 section deals with criminal liability for misstatements in prospectus. According to section 34, where a prospectus issued, circulated or distributed includes any statement which is untrue or misleading in any form or context, or any inclusion or omission of any matter which is likely to mislead, then person who authorizes the issue will be liable under 447. Either contains a misleading statement which is untrue or misleading in any form or context, or it includes or omits any matter, okay, which includes or omits any important material fact, then every person who signed the prospectus will be liable for fraud under 447. Okay. Further, 35(3) provides that where it is proved that prospectus has been issued with an intent to defraud the applicants, okay, or for a fraudulent purpose, then they will be personally responsible without any limitation of liability. In the given case, the non-disclosure of the fact that, sir, dividends are paid out of profits, you said, but you did not tell that it was paid out of capital profits. Dividends should be paid out of the revenue profits of a company, P&L profits, not out of the sale of assets. Okay. So non-disclosure of the fact that dividends were paid out of capital profits is a concealment of material fact. Okay. Hence, material misrepresentation has been made. So allottee can avoid the contract of allotment of shares. He can get the compensation under section number 35. And the directors and any person who authorized it shall be liable under section 447. Next. Explain the various instances. Okay. Explain the various instances which make allotment of securities an irregular allotment. Sir, irregular allotment is allotment not as per Companies Act. Okay. Companies Act does not specifically provide any term irregular allotment. Hence, we have to examine the requirements of a proper issue of securities and consider the consequences of non-fulfillment. Let us see. Where a company, what are the circumstances? Sir, very important 6 points. These 6 are irregular allotment circumstances, situations of irregular allotment, where a company does not issue prospectus in a public issue. That means without going for a prospectus, without issuing a prospectus, it went for a public offer. That's one first case of irregular allotment. Number 1, where prospectus issued by the company does not include any matters which are required to be included under 26(1). 26 subsection 1, some details are given. These are the information that should be there. Without that info, you gave first case the prospectus are not given. Second case like given, but it does not contain the particulars required under 26(1). Irregular allotment 2. Okay. I gave prospectus, contained information, but not filed with the registrar. Without registration, went for a allotment. Irregular allotment 3. Okay. Minimum subscription not received, but you went for allotment. Irregular allotment 4. Okay. Minimum subscription received, but it is less than 5% of the nominal value, because as per act it should be minimum 5%. I received only 3% of nominal value. Irregular allotment 5. Okay. In case of public issue, approval for listing has not been obtained from stock exchange. That means whenever you are going for a allotment, first you should enter into agreement with the recognized stock exchange to list the security. Without entering into listing agreement, you went first for the public offer. Irregular allotment number 6. That's it. Remember. Next. Next one, underwriting commission. Simple answer I will tell. Underwriting commission must be authorized by the articles. First point, if it is a shares, you can pay underwriting commission of 5% of the issue value, or any amounts mentioned in the articles whichever is lower. Whichever is lower. Debentures 2.5%. Here it is equity shares 5% you can pay. Next, shelf prospectus already completed, underwriting commission already completed for the debentures. These are all some important issues that one has to cover in the chapter prospectus. Remaining all the questions are only repetitive in nature. Try to cover them just by reading the question bank. Everyone in the class understood the prospectus chapter on a overall summary. Everyone? Okay. Thank you. Next session, I will cover the remaining concepts inside the company law and close.